Good evening, everyone. Thank you for your time and your patience as we get started here. I will call the Board of Appeals meeting to order at 5:34 p.m. Present, we have the Chair, Wendy Smith, John Tutenhoff, and also Steve Isaacson is appearing virtually. Also present, we have Inspector Burris, Attorney Bear, and the applicants for all three items that are listed here on the agenda. The meeting has been properly noticed and posted according to law. And now I will turn it over to the Chair, Wendy Smith.
Good evening. Welcome to this meeting of the Shorewood Village Board of Appeals. This is September 10th. Our agenda packet has a few items to consider before we get into the hearing matters. Item number 4 on our agenda is approval of meeting minutes for our meetings on June 11th and July 16th. For our board members present, are there any proposed edits or changes to the draft minutes as proposed?
No.
Can I have a motion to approve those minutes?
So moved.
And do I have a second? Those minutes are approved, both the June 11th and July 16th meeting minutes as drafted. All right, we have 3 items for consideration today, one of which is regarding downspout disconnection. The other 2 are variances. We have the benefit of having the village attorney here to explain the standards of review by which the Board of Appeals will apply. I consider perhaps we discuss the downspout disconnection standard first, and then we can revisit the village attorney to explain the variance standard. If that sounds all right, I'll pass the mic over to the village attorney.
Thank you very much. And I wanted to note that the ordinance regulating the downspout disconnection is a relatively new phenomenon in Shorewood and the other communities that also have, I think it's, there's not very many other than Shorewood, but that also have downspouts that go into the combined sewer area. So I thought it would be a good idea for those that are here to start with sort of the 30,000-foot view and then work to the village's specific ordinance. The purpose of the disconnection that was mandated by the Metropolitan or the Milwaukee Metropolitan Sewage District, or MMSD, is to alleviate pressure overall in the system such that the hope is we will have less backups into people's basements and less discharge of partially or untreated water into the natural waterways, including our lake. And so as part of in furtherance of those goals and as part of that plan, one of the things that they're mandating is that in the combined sewer areas, residential properties up to four dwelling units are being asked to disconnect the downspouts from the sewer. So in other words, if it goes right into the ground and then that's connected to the stormwater sewer below, they're asking to disconnect those to alleviate the pressure and then put less water into the system during large scale rain events. And again, with the ultimate goal of improving quality of life for everyone by not having discharges into a lake and other waterways of water that's only partially or not treated at all, and to avoid those basement backups. So that's part of a larger plan that includes green infrastructure and improvements to the deep tunnel, and also improvements to the other sewage treatment or sewage pipes that you've probably noticed, especially if you live in certain streets in Shorewood. I've suggested that those residents that have had their streets torn up for the better part of a year should probably get a gift basket or flowers at the end of that. But at any rate, I know that the village is very aware that it's been a trying time for many of its residents. So that's sort of the 30,000-foot view. And the other important thing to consider is that this mandate comes from MMSD pursuant to authority granted to it by the state. And based upon that statutory authority, the village, in my opinion, can't say, well, yeah, but, we don't want to do it in these particular circumstances, or, we think that there's a reason to avoid the enforcement at certain points. My opinion is, because it's essentially a state mandate through authority, through the MMSD, my opinion is that the Board of Appeals is not in a position to legally grant variances from the disconnection order. That is my opinion. Now, it doesn't mean that the Board of Appeals doesn't have any jurisdiction at all. So the Board of Appeals always has authority and jurisdiction to hear an allegation that the municipality or its officials improperly applied or improperly interpreted a portion of the code. So the particular portion of the code that's at issue, it says that in the combined sewer service area, discharge of water to the combined sewer system from downspouts of residential structures is prohibited if the following conditions are present. A, the roof drain is external. B, sufficient space is available to locate the discharge point at least 5 feet away from the basement or foundation walls and property lines. C, pervious surface is available at the discharge point. D, the discharge location is level or slopes away from the structure, but is not so steep that the discharge would cause erosion. And E, the discharge water will not create ice on pedestrian walkways or otherwise create a nuisance for adjoining properties. So the municipality, through its officials, makes an initial assessment to determine whether or not those conditions are present. And I know that this can be a hardship. It's certainly a change for a number of individuals, but the bottom line is, if those conditions are present, they have to be disconnected. So the village inspector's office has made a determination that those conditions are present. So here's how I would suggest that we move forward, is that we would swear in the inspector. He would offer some testimony and context to his evaluation and address the factors as enumerated in the ordinance. And then it would be the burden would then be on the appellant to demonstrate that one or more of those conditions are not present, and thus not triggering the disconnection, the downspout disconnection from the combined sewer area below the property. So I will, of course, remain here throughout the hearing, and would be happy to answer questions as they arise as we go through the process. But again, my suggestion would be for the body to focus on those 5 factors as enumerated in the ordinance. And just for reference, for the record, those are actually located in 2 places in Shorewood's code. The first one is in chapter 225 under building construction. There's a section addressing gutters and conducting water. And then the second place that it is listed in the village code is under chapter 415, under section 18, rain or surface water drainage under plumbing standards. So it's actually in 2 spots in the code, but the language is essentially the same. When MMSD mandated this, it was determined that it was appropriate to put it in both places for ease of reference by residents, so that if they were someone was looking at the plumbing standards related to that, or they were looking at the building code section, that they would find it in both places. So that would be my suggested path forward. And again, I'll be here to answer questions as we go through the process.
All right, thank you. Before we get into the specifics of this appeal, are there any questions for the village attorney at this time? Stephen, nothing from you. Will you entertain a question from the audience?
Sure, absolutely.
Yes, sir. Would you like to come up to the microphone?
A technical question. So you talked about erosion being, I'm trying to. Okay. So you talked about erosion.
Don't lick the microphone. Please.
Sorry?
No licking the microphone, please.
I'm trying not to, but you put it really close. So one of the criteria you quoted was that they should not cause erosion, right? So any discharge that goes onto loose soil clearly is going to cause erosion. So that is a criterion to not disconnect, or it's maybe a question for the inspector.
Well, I think, I mean, I think that that's one of the elements that will have to be evaluated by the Board of Appeals.
Right.
And will have to be addressed by the inspector as well. What I would say though is, it can't be a self-inflicted condition.
No,
You can't
that's
just
not,
tear up.
that's not the
you just
question I'm
can't tear up
suggesting at
the-
all. I mean,
tear up-
I have,
Well, let me finish.
Okay.
You can't just tear up the area and say, well, there's loose, there's loose soil there now. And so by definition, it would cause erosion if I unhooked it. There's obviously, the overriding purpose and intent is to disconnect so that people's, basements don't back up and we don't dump untreated
Right.
sewage into the waterways. So we're MMSD, we're erring on the side of potentially some minor inconvenience for the local property owners so that the greater good of not dumping untreated sewage into the lake is, that's the ultimate goal. So I think it's a balancing, you have to look at all 5 factors, and if they're present, then they have to be disconnected. So I think, why don't we save that discussion for after you can ask questions. If you're the property owner, you can ask questions of the inspector following his testimony, and we'll also swear you in and you can offer testimony as well. And you can also submit pictures if you think that, if you have pictures that show the property and how it relates to these 5 elements, you can absolutely do that as well.
well, I mean, you have some criteria.
Well,
No, I
I
think-
tell you
I
what,
think-
let's wait
no,
till
let
we
me-
swear
let me-
you in. Let's wait till we swear you in. Because
Okay.
are you the property owner? Okay, so we'll swear you in later. Okay.
All right, we'll call for consideration item number 6 on our agenda, request to appeal the village's enforcement EEN 24-000556 regarding downspout disconnection requirements at residential property 2615 East Menlo Boulevard. We'll begin with a statement from Inspector Burris concerning the downspout disconnection order, please.
Inspector Burris, can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. So Attorney Bayer, thank you. Nathan provided a very robust overview of the order that was sent and the reason for it. Within the packet, the Director of Public Works, Leanne, essentially she provided a memo that details much of the same there with respect to the program requirements. The property owner, upon receiving the notice, first emailed Leanne on April 16th, requesting an exception to the downspout disconnection. So on this property, there were 3 downspouts identified. 2 were exempt based on the conditions present. It was a village engineer, Strand and Associates, that conducted these initial surveys and provided the pictures for the reports that were sent out to homeowners. On May 23rd, the property owner once again emailed Leanne because she had not yet gotten back. And on June 5th, Leanne emailed back stating that it does appear that the use of an extension on the northwest downspout could divert water into the front yard. Given this option, based upon the code language, it seems that the minimum threshold could be met to require this downspout to be disconnected. As such, I cannot administratively provide an exemption. So then at that point, the property owner submitted the request for appeal, the interpretation of the village. Again, this downspout is on the northwest corner of the house. So it's at the front corner of the house. And the front yard is rather level, as indicated in the program requirements. That it is, let's see, discharge location is level or slopes away from the structure. Again, but not so steep that discharge would cause erosion. I don't believe steepness is a factor here, as it would discharge into the front yard. There is ample room. The roof drain is external. There is sufficient space, and it is not near, again, being at 5 feet from the lot line, would not be near a pedestrian walkway, or a sidewalk, so would not create a nuisance.
All right, thank you. At this point, I would like to acknowledge that the homeowners have filed an appeal for the agency's interpretation here. That appeal was inadvertently left out of the agenda packet. So I'd like to enter into the record what we have as the Board of Appeals application concerning this property, 2615 East Menlo Boulevard, which identifies this request as an appeal to interpretation to allow. What I have is 2 pages of an appeal form, 1 page of statement with photographs, and 1 proposal and contract from Slate Tile Shingles Roofing, Inc. Is that the extent of the material provided by the appellant?
Correct.
Okay. Those are entered into the record. Those documents have been provided to board members as well. All right. Board members, any questions for Inspector Burris at this time?
No.
Hearing none, is there a representative of the homeowners who would like to make a statement? Great. Please come to the microphone and again, speak into the microphone. Toya will swear you in before you begin. Feel free to make a statement or ask any questions that you'd like to provide information relating to this appeal.
Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please state your name and address.
My name is Harriet J. Black, known as Haji, which is why that's what Toya calls me. And I live at 2615 East Menlo Boulevard. I'm okay to go?
Yeah, Ms.
Okay.
Black, provide us with any information you'd like us to know about your
Yes,
property.
Yes, so this downspout on my beautiful 100-year-old home is about a foot away from the property line. There is extensive landscaping that's been done since the inspector was there by my next door neighbor. He had spent over $150,000 on the landscaping next door. So there's only 1 foot, there's exactly 1 foot between this downspout and his property line, okay? If I were to cut, and also this downspout that goes is mortared right into the sewer line, like the other 2. And because it has been there like that for 100 years, if you were to cut it and put I guess it would have to be a PCV pipe to get out to the front yard, it would have to go at least 20 feet away from there to get it far enough away from my house before I would get water into my basement, okay? So, and not only that, but where it would have to be cut is downhill from the front yard. I don't know how it can be said that it is level. I don't find it level at all. It's at least 2 feet before the trees in the front yard. So I think that both from the erosion issue of, and it also having to be sort of uphill in order to discharge, and for having to have a long 20-foot ugly rubber pipe against my beautiful 100-year-old home. I know historic preservation is not one of the factors that was read by the village attorney, but from my perspective, I see myself as the steward of this house for the time that I live here. And there's been many people before me, will be many people after me. And it breaks my heart to cut into this pipe like this. I understand the whole issue and the larger 30,000 issue, and I fully support it and agree with it. But we've had 2 of the 3 grandfathered, and what I'm asking is for the 3rd of this beautiful old copper to be grandfather as well on 2 issues that you read. One is I do believe it is much lower than the front yard and would have to go uphill. The second being that it's 1 foot away from the neighbor's property line, who has just invested a fortune in his landscaping. So I don't exactly understand. So you were not the inspector who saw it, is that right?
That is correct.
Yeah,
I
it was
did not
somebody else who
conduct
saw it.
the initial survey.
Yeah, so I would at least ask somebody to take another look. And I don't understand even how you would, that's why I was asked to get a professional opinion, and I got a professional opinion from this company, which is in the packet. And his opinion is that should also be grandfathered along with the other two downspouts. So I'm a big conservationist. I compost, I drive a hybrid. I fully get the issue. I'm supportive of the issue, but I think in this particular situation, it does not meet the criteria that are stated in the what? The regulation? The regulation, yeah. And first of all, I was going to start by saying thank you very much for having an opportunity to be here and to say my piece. I appreciate that very much.
All right, questions for Ms. Black?
Sorry, I have my back to you.
That's okay.
All right, so I just wanted to clarify what we think is the issue as it relates to the criteria that we have to
Yes.
base this off of. The northwest corner downspout is the only downspout that has been ordered to be disconnected. Is that
Correct.
your understanding? And that's the
Correct.
one you're appealing?
Correct.
Okay. And for the criteria that was explained by the village attorney, it sounds as if what you're challenging is sufficient space available to locate the discharge point at least 5 feet away from the basement or foundation walls and property lines?
Yes, I mean, it could be done. It's not that it couldn't be done, but I think it's undue hardship. I really do. I mean, it would have to be a pipe and probably it can't turn the corner, I don't think, with copper. So I think it would have to be done with PCV, and there would be a 20-foot rubber PCV pipe running out into my front yard to get it far enough away from my house. Yes.
And so is it your testimony that the area where there's only a 1 foot space between your property and the
neighbors.
the building of your home and the property line
Yes.
is 1 foot, and
Yes.
that extends for 20 feet?
No, it's 1 foot. So the pipe would have to go, instead of the pipe coming out, like most times, the pipe comes out from where the pipe is, straight out. That's impossible because it's only 1 foot of property. So the property would have to turn the corner and go up into the front yard.
And so what's the distance into the front yard?
Maybe 5 feet to the front of the house, maybe another couple of feet to the front of the balcony, which does get water into my basement from time to time. And then you'd have to go at least another several feet away from the house. So I don't think there is a 5-foot clearance there that you could put an extension pipe into.
Okay. And is that the only element that you're saying is not satisfied here?
And then there's the erosion issue of the fact that the cut in the downspout, which is usually done right above where the sewer pipe is lower than the front yard. And so you would have to cut it maybe several feet above that for it to be a downslope. So I think that, there is a potential erosion issue here as well. I'm not quite sure how it's even possible.
Okay, so your testimony is that
I'm sorry, I'm rambling around.
no,
So,
no, no,
yeah.
I just want to make sure that I got it right.
Yeah.
Is
let's
that
say-
the slope of the area surrounding the downspout is an uphill
Correct.
slope?
It would have to be re-leveled, yes.
Okay. Questions for Ms. Black?
Nope.
Is there another individual that might like to make a statement?
I guess
Seeing none. Okay, well, do you have any further statement that you'd like to provide us?
I do not.
Okay.
Thank you.
You can have a seat for now. Any follow-up questions for Mr. Burris in light of Ms. Black's testimony?
I'm sorry, does anybody want to see pictures of where the garden is compared to the downspout? The neighbor compared to the downspout?
That might be helpful. I'm not sure how Stephen will be able to see those pictures.
I have the pictures. I see it.
No,
No, she
I
needs
see
on-
I can see the packet. I have it up.
yeah, Stephen, I didn't have this one in the packet. Unfortunately, I didn't figure it out. and
She has
filled in.
additional photos.
I have a photo on my phone. Can I bring it
Here-
to these folks and then try to hold it up to the camera? Will that
No,
work?
Harriet.
Oh,
can you
that's
just
not
em-
it's not necessary. I've got the picture.
Okay,
I'm processing this.
alrighty. Do you want me to just email it to you, Tanya?
Is that what you would prefer?
Or
If you
I
could.
can show you here.
No, emailing would
If
be
you
best,
can
then I can
perhaps
share it.
Share it
Alright,
with
mhm.
us.
Yes.
In the meantime, do you have Toya's email address?
Do I have Toya's email address? I'm not sure I have it like easy here though. Let me try.
Okay. While you're doing that, I do have a question for Inspector Burris. Inspector Burris, can you give us some clarification about your understanding of the property and the downspouts disconnect, or the downspouts proximity to property lines and enough clearance space for disconnection? We weren't, I don't have a
Yes,
plat.
most definitely. Yeah, so with respect to the discharge point, so there is no requirement that when say a downspout is extended to get away from the building foundation or property lines, that it has to be run in a straight line. We have had people bury that, say, downspout leader in the front yard and daylight it on a hill. We've had them bury them in the yard into like a pop-up. So when, again, heavy rain event, it essentially, pops up and lets that water flow out into that discharge point. So it can be routed, a million different ways. It's not that it has to be run straight out. There's no dictum on what material is used. So again, the idea and the basis behind the program is that there is a discharge point. If it is the case that that the front yard is higher than location of where the downspouts entering that standpipe receiver, that too is that wouldn't contribute to erosion. It's a matter of the discharge point, and is that on an incline where when the water is discharging at that location, it would create erosion. So again, the initial engineer, again, they looked at 3 on this property and exempted 2 for the reasons listed here that, again, there may have not been sufficient area. And this one that they did determine that, yes, the front yard is sufficient space and that can be directed. Again, there's no directive on how that's achieved, but that space is available.
Question, is this information you just shared available someplace on how to do this? All the examples that you just gave?
So in the initial letter that was sent out, there is a link to the MMSD site that may have some information on that. And the pipe check program, MMSD has, say, contractors, say preferred contractors that anyone could get in touch with. But again, because we don't mandate how it's done, and some people have a landscaper do it, some people do it themselves, a handyman. There's all methods and ways to go about doing this. So other than, again, the MMSD website and the village's page on downspout disconnections, there isn't anything beyond that details all that.
So if I'm understanding, is it possible to discharge this downspout and comply with the criteria as stated, where this states locate the discharge point at least 5 feet away from basement or foundation walls and property lines? Is the only mechanism for doing that in this case, with your knowledge of what the property looks like, with a over the grass extension of the downspout? I guess I don't want to ask you too much technical
Sure.
information about how gutters or downspouts work,
Right.
but I'm just wondering, this is a tight spot.
Yeah. So again, in my opinion, no, it would not necessarily have to be run over ground. And keeping in mind, and I understand that was a lot of the information provided in the appeal, but aesthetics are not a consideration. I mean, that's just, as much as we can appreciate them, if it were the case that it had to be run on a pipe over the lawn, there isn't anything within that program requirements that says, you know, if it's not going to look nice, we don't do it.
Attorney Bayer?
Thank you. I just wanted to make a quick clarification because there's a lot of terms of art that are being used in the ordinance and that we're talking about here. So the discharge point is not, if you look at the photo on page 9 of the packet, it's not the bottom part of the pipe where the vertical stretch of the pipe comes from the eave of the roof down to the ground. The discharge point is wherever else it's going to turn and then come out somewhere else in the yard after it's disconnected from the sewer. So instead of going down in that rubber pipe there into the ground, there's going to see you as what you see as sort of the traditional downspout where there is a bend. And then in some cases, there's a long metal piece that matches the vertical downspout. And it might be 4, 5, 6 feet long. And then that's the discharge point where the water ultimately is deposited. Or in some cases, you see that sort of spongy looking rubber sort of hose that snakes around the building and discharges another. And as the inspector indicated, sometimes they're buried and they come out towards the front of the house, you know, through a berm or something like that. So ultimately, the question is not whether or not the bottom of the vertical pipe where it's next to the house, whether this criteria applies there. It's the real question is there a suitable discharge point in the area where there's sufficient space available at least 5 feet away? Is there a discharge point that's, you know, that meets that criteria? Is there a discharge point where there's pervious surface available? Is there a discharge point and location available on a level or a sloping away from the structure so you don't get all that water dumping back into the basement or around the foundation? And is there a discharge point where available that it will not create ice on pedestrian walkways? So that's really the question. Is there an appropriate discharge point? I just wanted to point that out so that people don't think that the discharge point is the bottom of the vertical the vertical pipe that you see like on page 9. Did I do a good job of explaining that?
Yes.
Okay, all right. Just wanted to clarify that.
Inspector Burris, can you reply to the appellant's statement as to slope, as to whether your inspector who went out and visited the property assessed whether the discharge location is level or slopes away from the structure, but not so steep as the discharge would cause erosion?
Yes, again, the discharge location is level or slopes away. The proposed discharge location being the front yard is rather level.
Heather,
Yeah, when we think of erosion, we think of most generally the only other time that outside of say the river district where we don't have any homes is on the lake bluff. And so that's the only other time where erosion is mentioned in the village code with respect to the setbacks on the bluff. So we're talking about a significant slope where erosion would be detrimental to a property. Not, you know, it rains and there ends up being a soggy spot in the yard for a couple days.
I have one final question for the village attorney. Given that the village's inspectors have been out to this property and have assessed the property, whereas we are relying only on written statements and a few photographs, is there any weight given to the decision of the agency given its expertise?
Well, certainly that is something that the body can consider when it evaluates the evidence. If you look at specifically on page 9, 10, let's see here, 9 and 10 of the packet, you'll see that it says Strand and Associates Downspout Review, Village of Shorewood, Wisconsin, site photographs. So what Strand did, they were hired for their expertise, knowledge, skill, training, and experience to go out and evaluate properties in the combined sewer areas. And based upon that knowledge, skill, training, and experience, take these photographs and draw these conclusions. And with respect to 2 of them, they concluded that, hey, we see conditions here that would, as listed in the code, that would mean that 2 of the 3 did not have to be disconnected, but the third one qualified. And you can see that's on page 10, or page 9. It says they visited on July 21st, 2023, has the address, description, connected, and it says not exempt from discharge, northwest corner of the structure. So they did their analysis based upon the criteria listed in the ordinance. They took some photographs. There's some highlighting there on the photos. And that was, again, as engineers, and I think the fact that, they played it down the middle and were straight is the evidence of the fact that 2 of the 3 they exempted and the third one they didn't. So you can take that for what it's worth. But yes, I think you can give additional credence because the report was done by a professional engineering firm.
Any further questions from the board? Toya?
I would like to just state for the record that we have a written support from Sue Bronson that states that I am in support of keeping the beautiful copper pipe as it is.
Is that a neighbor?
She didn't state her address, but I'm sure she is, yes.
Okay. All right, if we're ready to proceed to deliberation amongst the board and close the hearing testimony or the testimony component of this hearing, is there a motion a member would like to propose so that we can enter discussions?
So moved.
I think we need to verbalize what the motion is.
We proceed to discussion on this matter.
Okay. That's sufficient for entering into discussions. Any thoughts on whether this property and specifically this downspout meets the criteria for disconnection such that we agree with the agency's determination?
And can we discuss this at this time?
I think there was unanimous consent.
I'll second that motion if we, yes, we can enter
Unanimous.
deliberation now.
You can just ask if there's unanimous consent to deliberate, and you don't need to take a vote.
Do we have unanimous consensus to enter into deliberations? Okay. Stephen, did you have a comment?
Yeah, reading this and listening to this, I understand the letter of the law for the ordinance to disconnect. It's interesting that 2 of these downspouts in this historic house were grandfathered and that this one was not. And I'm sure that was done on the basis of the technical analysis of the, about not disconnecting the other 2, that it was within practicality to leave them hooked up. On the other hand, I'm interested that if 2 were grandfathered in this historic house, why wouldn't they grandfather the third one because of the construction? I understand it's an ordinance and I understand the evaluation, but practically it would seem to me that all 3 of them should have been grandfathered in the 100-year-old house. And I understand that the historic preservation is not a criteria here, but in fact it is in practicality. The contractor who they hired to evaluate the situation said if the roof were removed and the gutters were removed, then obviously there would be no grandfathering and they'd have to deal with the circumstances at present. But I am concerned that historic preservation is important here. I know it's not to the letter of the law, but it's something that's weighing on my mind. And I think that it's not clear that if they were to, put another extension on this, run the pipe out somewhere, I understand the neighbor's a foot away, and they'd have to turn the corner and get away from that, would have some impact on the property. It could have some impact on the value of the property. And so I'm just thinking that there is a practical way to evaluate this versus just, adhering to the ordinance. So anyway, that's what I'm thinking.
Thank you, Stephen. Further comment? I will say in counterpoint to Stephen's comment that there are a significant number of homes that are 100 years old. I happen to live in one as well. So I understand the concern about historic preservation, but just looking at what is required pursuant to state statutory authority, we have some specific criteria. Otherwise, downspouts must be disconnected. I understand the concern about aesthetics and wanting your home to maintain its historic character, and it's a beautiful home. But I worry about whether our exceptions to the disconnection might be broader than we should, given that there are many beautiful homes in the village. There are many very old homes in the village. And so we're looking at this from an aesthetic purpose, and it does seem that the statement by the contractor is concerned about, the historically correct look of the house. That's just not as persuasive to me as perhaps some of the other elements that were discussed during the hearing. As for whether there is sloping, the discharge location, I'm having a hard time finding grounds for disagreeing with the agency's decision, especially since we don't have the benefit of being on the ground and looking at it. So those are my initial thoughts.
Wendy, let me just comment.
Yeah, go ahead.
I understand what we're voting on. I understand we're voting on asking for a variance to the ordinance, but I just wanted to be on record as saying that I am very sympathetic to the aesthetic nature of this property. I'm very sympathetic to the homeowners concerned, but I understand what we're voting on. So I just wanted to make that clear.
Okay.
Yeah, I'm quite sympathetic about it also. But our points here, the 5 points that everybody's going by is I think have been taken into consideration by the engineers that have actually already been out there. And I don't know if we've explored all the ways to resolve it on the homeowner side at the moment. So I unfortunately see this as good consideration that they've already been out there twice to actually check it out, and I'm going to go with that. Especially the pictures that were presented here today. This was the inspector's second visit. And on the pictures that were presented by the inspector and that the homeowners brought in too, that back corner there, I can see a lot of land space. Not a severe drop off or anything else either. Yeah, I feel like there's been a good deal of investigation here.
Any further comments? Are we ready to proceed to a vote? Hearing no further comments, I guess I'll propose a motion. Is it better to move to affirm or move to reverse? Is there a preference on phrasing?
Kind of thinking.
What is the easiest?
Exactly. Just to affirm one possible motion. Decision in order Don't vote.
Okay, I'll phrase this as, I move to affirm the decision and order of the Village of Shorewood to disconnect the northwest downspout at residential property 2615 East Menlo Boulevard.
I second the motion.
Thank you. Toya, can you call this to a vote? And again, that would be a vote. I would be to affirm the agency's decision.
John Tutenhoff,
Aye.
Stephen Isaacson,
Aye.
Wendy Smith.
Aye.
Motion carried 3-0.
The agency's decision is affirmed. Sure. Moving on to item number 7, request for a variance of Village Code 225-7 sub 4 to allow an air conditioning condenser in the side yard setback at residential property 4339 North Alpine Avenue. And we'll begin with Attorney Bayer providing us with the legal standard for a variance request.
Thank you. So the members of the Board of Appeals are very familiar, of course, with this process. So I'm going to direct my comments generally for the benefits of those that are joining us this evening, the appellants and any guests that we have. So the power to grant a variance is specifically authorized by Chapter 535 of Shorewood's Village Code. And what that means is to basically grant an allowance to go outside the parameters of something that would be required by Shorewood's building permit. And the specific code provision says that this body has the power to hear and grant appeals for variances as will not be contrary to the public interest where, owing to special conditions with respect to the person's property, a literal enforcement will result in practical difficulty or unnecessary hardship, so that the spirit and purpose of this chapter, and by this chapter they mean the building code and the zoning code, shall be observed and the public safety, welfare, and justice secured. So just to give you an example, some grounds that have been used to grant other variances are situations where there might be an unconforming lot because it was constructed or created before the advent of the building code or the zoning code. That's just one example as a concrete. So in order to grant a variance and allow something outside the confines of the building or zoning code, there's a specific finding that has to be made in the record. And that would be reflected in a motion if there was a motion to grant. And that would be the first one under 535-58 is exceptional circumstances. So there's a definition of that. It says that there must be exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, parcel, or the structure that do not apply generally to the other properties in the same district. And granting of the variance would not be of so general or recurrent nature as to suggest the chapter should be changed. In other words, another way of saying that in regular parlance is the exception should not swallow the rule. So the first finding is exceptional circumstance. The second is absence of detriment, that the variance will not create substantial detriment to the adjacent property and will not materially impair or be contrary to the purpose and spirit of the zoning or the zoning or the building code or the public interest. So as you present and show evidence to the body today, those are the two things to keep in mind. Focus on any exceptional circumstances applying to the lot, parcel, or structure, and then demonstrate how there may or may not be absence of detriment.
Thank you. Any questions for the village attorney at this time? We will start with a statement from the village first, and then I'll call you up. Questions for the village attorney? Hearing none. Inspector Burris, can you please provide us a statement as to this request for variance at 4339 North Alpine?
Yes, thank you. On March 7th, 2024, an HVAC permit was issued for the installation of a furnace and AC unit. Upon final inspection on June 17th, 2024, A notice of correction was issued identifying that the location of the condensing unit was within the side yard setback area by 8.5 inches approximately. The village received the Board of Appeals application on July 30th. The applicable zoning regulations, again, 225-7F, states air conditioning units may not be located in front yards or rear or side setbacks. The conditions of the lot are, so a minimum lot width in this district is 40 feet. And this property conforms 49.6 feet on average. Minimum lot area is 4,500 square feet. This lot is 6,173. And again, the setback 3 feet. And what we have right now is 27.35 inches, less than 36. Within the packet, we have the HVAC permit application, the issued permit, page 13 of the packet. So I just want to draw your attention to the issued permit. Again, page 13 is on the permit that was issued and gets sent to the contractor. We actually now include the stipulation of section 225-7F that states air conditioning units may not be located in front yards or rear or side yard setbacks to try and prevent these incidents from occurring. We have had other AC units in setbacks come before the Board of Appeals in the past. And so, again, we include that now on the issued permits to the contractor to try and not find ourselves in this situation. It was a replacement of an existing AC unit. We also, again, have the Board of Appeals application, neighbor letters of support, property survey, and pictures.
Inspector Burris, when they're submitting an application for a permit, are they required to supply kind of the location of the AC unit?
They are not.
Okay. Questions for Inspector Burris? Okay, to clarify here, the issue is side setback encroachment only?
Yes, yeah. Again, by 8.5 inches.
Okay. All right, representative of the homeowner that would like to come up and make a statement, please come up to the microphone. Toya will swear you in.
Okay.
Can you raise your right hand?
Yes.
Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Sure. Krista Sofia Quintus Menendez, and my address is 4339 North Alpine Avenue.
All right, what can you tell us about your property? Focusing on the criteria that we have to apply
Yep.
here, whether there's exceptional circumstances relating to where the AC unit can
Can
go.
actually be. Yep.
Right.
So the AC unit it's a replacement unit, and it's in the exact same location that it's always been. I only have records since 2008, so that's what I'm going on. And it's located because it provides direct access. The electrical box provides direct access into the basement. The adjoining addition, if you will, is on a slab, so it's can't bore through I suppose you could bore through a slab to pull the lines through. So it's there because that's the easiest access to the house. If it was relocated, it actually really does require extensive electrical and piping, and I would have to probably replace siding. How the unit is, and as Donovan and Jorgensen explained, is that to relocate the unit and have the oils, piping,
Line set.
thank you,
Yeah.
the line set, move from where it is to around the back of the yard. I'd have to have a really long line set. It would attach to the siding. I'd probably have to replace some of the siding, which is old. So I don't know that I would be able to find a match. And the unit, it really doesn't, it doesn't stick out much from the house. It's tucked behind the chimney, so you can't see it. It's always been there. It's replaced with a more high efficiency unit. So my hardship would be an additional, I've already spent replaced the HVAC unit to have a more efficient AC unit. I'm already $9,000 in. It would cost an estimated $3,000 just to move the unit. And if it were in fact moved, I don't know what it would cost then to replace the siding and regrade. I'd have to move some land and stone, like a little land and stone pathway where that's there right now. I mean, it becomes quite burdensome and really not necessary since it's always been there. And as you can see from the photos, the two houses, that space in between the two houses, it's really utilitarian. There's no walkways. We don't walk back and forth between them. I keep, my wheelbarrow there. The neighbors keep their old pots from the summer. They put them back there. So it's not something that would cause, it wouldn't unnecessarily burden my neighbors who've been there for 30 years. I think what else? It doesn't cause a public, it doesn't cause a public nuisance. You can't see it from the street. Technically, it could be moved. Would it cost a lot of money? Would it be more unattractive? Yes, because you'd see line set. I'd see the condenser from the back of my windows. Right now, you can't see it. It's tucked away.
So, what we're looking for is exceptional circumstances or properties of the lot itself.
Sure.
At least what the variance criteria does not take into account is how much money it would cost to relocate the AC condenser or whether it would just look ugly.
Sure.
So tell me
Yep.
more about is there any movement in its current location where it could scoot in by 8 inches?
So I actually asked that. I asked Donovan and Joyce and I said, can't you just tuck it back closer to the house? And it creates, you can, but then they don't have work clearance. And so.
All right, so I'm looking at the kind of the overhead property description, and it looks as though if you were going to replace it in the backyard, it looks like there is a structure added onto the back of the house. Can you kind of explain what that is? I know it's hard because you can't see what I'm
Sure.
looking at.
So it's actually an old screened-in porch that's now a family room. So there's no basement, there's no foundation. It's on a slab.
Okay.
And it's sided. There's siding. There's just siding along the area that we're talking about. And then as you turn, there are some windows.
Okay, and so is there a functional reason why the AC unit could not be placed there?
I couldn't open my windows. They don't lift up and down. They kind of telescope out.
Okay. Questions for our applicant?
So to understand the situation, the existing unit is grandfathered in, and by changing the configuration of the HVAC, this is now in violation of the ordinance to have the unit it should be less visible. Is that what we're talking about?
No, the AC unit was replaced in the same spot that it's always been.
Okay.
And its location hasn't changed. I believe that probably the building code has changed.
Right.
It's encroaching into the 3-foot side yard setback.
Yep, it's 8 inches. It's still on my property line, but it's 8 inches over the 3-foot allotment.
So are they requesting that you move that whole unit or just make a modification?
That it's modified, that it stays where it's always been.
And what's the issue that confronts you as expense?
And the and relocating it, yeah, my choices are I don't think you can bore through a concrete slab to pull the lines through. And then I wouldn't be able to, if it's relocated around the back of the property, I can't open my window.
Got it.
The unit is higher than the window.
Okay, I understand. Thank you.
I mean, technically, I guess I could not open that window, but then that really falls into, I feel like, burdensome.
Any further questions?
Yeah, so that new unit's on a slab, right? And that was
It
the existing slab that was there?
No, it's a replacement slab.
Oh, okay. But this is essentially, is it that much larger than the previous unit?
It's taller.
Taller, okay.
So is it your testimony then that there is no location in the backyard where this could be placed?
That's my statement.
Okay. Because the statement of the contractor proposes that it could be moved with the consideration being that the cost, the surface mount of the line set and electrical lines due to slab.
Yeah, I mean, it technically can be moved, of course.
Yeah, that's what I'm asking.
Oh, yeah.
Okay.
Definitely.
Okay, so
Yeah.
it can be moved somewhere else.
Yes.
Okay. Further questions?
So the question is, does it need to be moved? That's the question.
Yes, I would like to keep it where in its current location.
Got it. Thank you.
Okay, any further
Motion,
statement you'd like
discussion?
to provide?
I mean, I don't know. I think that not being able to open a window is a pretty legitimate reason not to move an air conditioner where it's always been. And my neighbors have no problem with its current location where it's always been.
Okay. Is there consensus to close the testimony portion of this hearing to enter into deliberations?
Yes.
Yes.
Okay, thank you.
I'd also I'm sorry, I'd just like to reiterate that the space between the houses is utilitarian. It's not, there's no walkways, there's no landscaping. It looks actually from the picture that I probably have a downspout problem. There's a lot of water in between the houses. That's it.
Okay, great, thank you.
Thank you.
All right, board members, any thoughts on whether this meets the criteria for a variance? And to reiterate what the village attorney mentioned, we are looking for exceptional, extraordinary, or unusual circumstances applying to the lot, parcel, or structure that do not apply generally to other properties in the same district. Granting the variance would not be of so general or recurrent of nature to suggest that the zoning code chapter should be changed, and the variance would not create substantial detriment to adjacent property or materially impair or be contrary to the purpose and spirit of the municipal zoning code chapter.
From the testimony, even of the neighbors of it being, them being there for 30 years and not having a problem with the old unit on the side of their house. And respect to our village inspectors, I mean, they can't determine who gets grandfathered and who doesn't. That's kind of where we come in here with a variance. But I would see it as being an unnecessary and unusual hardship to just arbitrarily try and put it to the back of the house. I don't think that they did this, the contractor himself made a responsible decision there and put it right where the last one was. Especially since this isn't going out any further, it actually just goes up further. Otherwise it is,
Well, I think it does go out. I mean, it does encroach into the side setback, right?
not any bigger than the last one.
Right. But
It's-
it is in current
is a-
violation of the setback.
But, right, yeah.
Yeah.
But, and I know when we improve things that we try and make them better. But, otherwise I'd see it as Well, it would be unnecessary of actually trying to put the whole unit to the back when the electricity and everything else is already hooked up right there.
Stephen, any comment?
Yeah, I think that the idea that she would not be able to open a window would have an impact on the real estate value, down the road. And I find it unnecessary to have to move that. So I'd be swayed by that argument.
Yeah, I think that's a good point about opening windows, and I do wish we had a picture of that back area so that we could see that there actually are, not that I disbelieve, but it would be helpful to see that placement of the AC condenser actually would pose a hardship to having proper ventilation, but I think that the testimony of the homeowner is credible and reliable. So without, photos, I think if placement of the air conditioning unit in the backyard would pose a hindrance to air and ventilation in that area of the home, then that would seem like unusual circumstances applying to the lot, parcel, or structure. Any further thoughts?
No.
Are we ready to proceed to a motion?
Yep.
Okay. I don't mind making the motion again. I move to grant a variance of Village Code 225-7 sub 4 to allow an air conditioning condenser in the side yard setback at residential property 4339 North Alpine Avenue as meeting the criteria for granting a variance. Toya, can you call a vote? Or, excuse me, do
I'll
I have a
second it.
second? Thank you.
Wendy Smith,
Aye.
Stephen Isaacson,
Aye.
John Tutenhoff.
Aye.
Motion carried 3-0.
Variance is granted. You're welcome. I believe you'll get notice mailed to you. Okay. All right. Item number 8, our last matter. I'm sorry for the long meeting tonight. Request for variance of Village Code 535-19F to construct a detached garage in the rear and side setbacks at residential property 4044 North Prospect Avenue. We'll begin with a statement from Inspector Burris when he has a moment. Then I'll ask for a statement from the homeowners after that point. And to confirm, Attorney Bayer, our standards for variances apply?
Standards will be exactly the same as the last application.
Okay, so
Once
while
again,
Inspector Burris
focused
is
on,
indisposed.
once again, focused on exceptional circumstance and absence of detriment.
Inspector Burris, when you have your bearings, can you provide a statement as to this property 4044 North Prospect Avenue?
Yes, thank you. So yes, the property owners of 4044 Prospect are seeking a variance to construct a new 13 by 23 single car detached garage within the setback area. The village received a building permit application on August 15th, 2024 to raise a 12 by 18 detached garage and construct a new 13 by 23 foot detached garage. The application was denied on the basis that the new garage is being proposed within with only a 2-foot rear and side yard setback. The current garage does comply with the 3-foot setback requirement. Again, applicable zoning regulations 535-19F for the setbacks, rear and side are both 3 feet. The site conditions of this lot is that, again, minimum lot width in this district is 40 feet. And this lot is 40 feet. The minimum lot area, 4,500 square feet. This lot is 5,174 square feet. The max area for a house on this lot, so 30% would be 1,552 square feet. And that part of this is a legal non-conforming. The house is actually larger than what the current code allows, 1,831 square feet, plus or minus. based on the area of the lot, they would normally be able to have an accessory structure up to 517, and they're only proposing 299. Again, what is non-compliant about this application was the 2-foot proposed setback instead of the 3-foot. Green space has also been looked at and confirmed compliant with the new larger garage. Minimum required is 1,552, and proposed with the new garage would be 1,841. We have the building permit application, the denial letter, the Board of Appeals application and supplementary materials, property survey and map.
All right, thank you. So the only thing at issue here is the rear and side yard setbacks.
Correct.
Okay. Questions for Inspector Burris? Do we have a representative of the homeowner that would like to make a statement?
Can you please raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Thank you. My name is Amy Shapiro and I live at 4044 North Prospect Avenue. With me is the other owners, Ruth Irvings. Thank you very much for allowing us to present here. I think as Mr. Burris indicated, we are asking for 2 feet instead of 3 feet on the east and south side of the garage. We currently have a Model A, I guess we could call it a garage, although the assessor called it a shed when we called once. We've been living there for 34 years and finally realized we needed an actual garage. The house, I think as Mr. Burr said, is larger, and you can see that from the GIS picture and the drone picture, I think, because there is a small built-in patio porch. It goes into the backyard. We have a postage stamp backyard. We would love a double garage, but of course we cannot fit that in there. We can only fit a single garage. But even with that, we have two doors, and I think you can see that from the first picture that we had. 2 doors, one coming from the porch and one from the back door on a tiny deck with one set of stairs going down. It would be really, really difficult to manipulate through that small area to get to the backyard, which again is a postage stamp size, either from the stairs or because the garage is going to come out farther, or from a side door to take out the snow blower, the mower, or whatever. It would be very, very difficult. What we're asking for is that there be more green space that's usable in the backyard. We're hoping to be able to landscape finally, and now that we would have a garage there, to be able to use that. So we think it's unusual to meet the first criteria because of the size of the house that was there at the time we purchased this, with that extra enclosed porch, that there's just not enough room there to manipulate. The other thing is that to meet the second criteria, the absence of detriment, we have both the east side neighbors and the south side neighbors who have written to support our position. We have as you can see, there is a fence right there already. It's not going to be any closer to the house or the garage of our south side neighbors. And it's right behind the other person, the east side neighbors. There's a little bit of a garden and then their garage. So it's not going to impinge on their view. It's not going to make them feel like it's closer because they already have that fence and it's far enough away from their living situation. So we don't think that it's detrimental, and it would be very helpful, I think, to the whole community if we can improve our lot and improve the Model A shed that we have right now, and allow us that passageway into the backyard as well into the side door of the garage.
Any further statement from any other representative? I do have a question. Do you
Yes.
intend to use the garage for vehicles, like car or motorcycle or what have you?
we have not been able to ever since we bought, because, you know, they have the doors that pull out like that. So we just have stored things in there. We've never been able to use it as a garage. We're hoping to be able to get one of our 2 cars in there, but also have enough room within it to be able to put our snow blower, which I finally consented doing. I love to shovel, but I needed one and a small lawnmower. So, and our bike. So to fit all that into a small garage too, we needed that extra foot to be able to do that, but we're hoping to use it now as a garage, yes.
The reason why I ask is I know that we've had matters similar to this where there's a very small lot size, very large house, and a conforming garage would make it challenging to navigate a car into the garage if it's set closer to the house. Do you think that that would pose a challenge given the angles of your home? If you imagine the garage being shifted one, either staying as it was or shifting 1 foot over and towards the house, whether that would be a hardship in navigating a vehicle inside?
Well, I absolutely think so. Because if you can notice on that first picture, the steps come out from the back, the back, I would call it, you know, it's like this big, but right there. And with the garage being bigger, it's going to be a little bit higher. And so I think it would be very difficult if we didn't have that extra foot over to be able to manage that. And we have some issues with vision in our family where having that extra space will really help us get that car in because of that inability. I think as we're getting older, we do have that problem. So it would, I think, be very, very difficult. I'm not sure actually we could use it if it was 1 foot over. I have to be honest with you.
Okay, questions for the homeowners?
Are you doing a driveway at the same time, or is it just the shed or garage?
We're just, we're just doing the garage. They have to do part of the driveway, just the beginning part, they have to take that out, but the whole driveway we weren't going to do, no.
Okay.
Yeah, my perception is that what you have now is a shed and not a garage. And if you put a proper garage on the property, that would help the property value. And I think the village would like that as well. So I'm sympathetic to that. And your arguments about navigating. But it's clearly a shed. It is not a garage at the moment. And that would change, right?
It would, yes.
Is there any other information you'd like us to know?
Just a little bit more, when we talked to JD Griffith, who's making it for us, he even thought that even if we had it over, we're going to probably have to cut that deck, the corner off to be able to even manipulate. So we're already really, really tight even with that. So we don't want to have to lose everything there, the entire deck, because then we'll have 2 sets of stairs instead of 1, which we have now. It will make it much more difficult, but that's all.
Okay, thank you.
Thank you.
Do we agree to cease the testimony portion of this matter and enter into deliberations?
So moved.
Yep.
Okay.
Mm.
All right. So our criteria for granting a variance here, I think we have a legal non-conforming structure that is larger than currently allowed by the code, but places challenges for the homeowners in that it takes up a sizable percentage of the lot size, resulting in difficulty in actually having a usable garage on the property, especially if you intend to use that garage for navigating of a vehicle. So I think that the size of the legal non-conforming home could satisfy the criteria as exceptional, extraordinary, or unusual circumstances applying to the structures itself. In addition to the additions of porches to the home. And we do have evidence on the record that Neighbors have expressed support for granting of a variance, so it doesn't look like we have substantial detriment to any adjacent property. Any further thoughts?
Yeah, I'd also like to say that as Justin iterated here, is that it's in compliant with the green space as well. We're not actually taking away more land. Somehow we're able to fit a garage in there in the postage stamp backyard.
Stephen, any thoughts?
No, I'm just, I'm also a member of the Board of Review and I'm considering, from that standpoint as well.
Okay, would anyone like to make a motion to vote on for this request?
Sure. I'll make a motion to approve the variance to code section 535-19F, allowing the detached garage at 4044 North Prospect Avenue to be within, what we say, 2 feet of the setback requirement.
I second.
Second,
Toya, can you call a vote?
John Tutenhoff,
Aye.
Stephen Isaacson,
aye.
Wendy Smith.
Aye.
Motion carried 3-0.
Variance is granted. You're welcome. With no other items on our agenda, this meeting is adjourned.
Meeting adjourned at 6:55 PM. Thank you,
Thanks, Stephen.
Stephen.
Thank you.
Have a good night.